On the afternoon of January 20th, 1649, in the great medieval hall of Westminster, a court of law did something that no court in English history had ever done. It put a king on trial for his life. The defendant was Charles Stuart, Charles I, King of England, Scotland, and Ireland. He believed he had been made king by God. He believed that no earthly power, no parliament, no court, no army had any right to judge him at all. The charge was treason, a charge that by every tradition in England could only be committed against a king. Now, for the first time, a court proposed to convict a king of treason against his own people. This is the trial of Charles I. To understand the trial, you have to understand that England in 1649 had just survived nearly a decade of civil war. For years, King Charles I had been locked in a deepening struggle with his own parliament over money, over religion, over the fundamental question of who truly held power in England. Charles believed in the divine right of kings, the doctrine that a monarch answered to God alone and not to any parliament of men. That struggle turned into open war. From 1642, the armies of the king fought the armies of parliament across England, a brutal conflict that historians estimate killed by war and disease a staggering share of the population. And Parliament's side built something new to win it, a disciplined professional force called the New Model Army. The king lost the war. He was captured. But here is the problem. That produced the trial. Even defeated, even a prisoner, Charles was still the king, and from captivity, he kept negotiating, kept maneuvering, and then encouraged a second civil war to break out on his behalf to the leaders of the army. That was the unforgivable act. They had beaten the king once, and he had simply started the bloodshed. Again, a faction in the army concluded that there could be no peace in England while Charles Stuart lived, that the king himself was, in their words, a man of blood. But the army faced a problem with no solution in existing English law. There was, quite simply, no court that could try a king. Every court in England ran in the king's name. Every judge held authority derived from the crown. The whole machinery of English justice flowed downward from the monarch. You could not use the king's own courts to try the king. It was a logical impossibility. So the trial's organizers turned to the only body they could claim spoke for the people, Parliament, but not all of it. In December 1648, the army physically purged Parliament. Soldiers stood at the doors of the House of Commons and turned away every member likely to oppose, putting the king on trial. What was left was a small fragment, mockingly nicknamed the Rump Parliament, and that rump passed an ordinance creating from nothing a brand new court, the High Court of Justice. When the House of Lords refused to agree, the Commons simply declared that it could act alone. The court was to have around 135 commissioners as its judges. But here is the most telling fact of the whole proceeding. Many of the men named to that court wanted nothing to do with it. They were afraid. They thought it unlawful. On most days of the trial, only around 68 commissioners dared to take their seats and to preside over it, to sit as Lord President and judge a king. The great senior judges of England refused, one after another. The roll fell, at last, to a relatively obscure provincial lawyer named John Bradshaw, a man who was so afraid of assassination that, for the trial, he wore a specially made hat lined with steel. The trial opened on Saturday, January 20th, 1649, in Westminster Hall, a vast medieval stone hall that had hosted English coronation feasts. For centuries, the setting was deliberate theater. A king was to be judged in public, in the open, in the most famous hall in the kingdom. Lord President Bradshaw took the central seat. The prosecution was led by the Solicitor General, John Cook. And then the king was brought in under armed guard. Charles I entered the hall, dressed in black, wearing the silver star of a royal order. He did not remove his hat. To the court, a deliberate signal to take off your hat was to acknowledge an authority above you. Charles kept his hat firmly on his head. Then the clerk rose to read the charge, and every word of it was revolutionary. Read that carefully. The charge claimed that the king held only a limited power, that he was trusted by the people, and that by making war on his own people, he had betrayed that trust. It was a theory that turned 1,000 years of English kingship upside down. The king was not the source of the law. The king was under the law. When the charge was finished, every eye in Westminster Hall turned to Charles Stuart. The court waited for the king to enter a plea, guilty or not guilty. And Charles did something the court was not prepared for. He refused to plead at all. What Charles I did over the next several days is the heart of this trial. And it was, in its way, a brilliant legal defense, even though the king never once argued the facts. Charles understood that if he entered a plea, guilty or not guilty, he would be admitting that the court had the authority to take his plea. So instead, the king attacked the one thing the court could not defend: its right to exist. This was the trap Charles set, and it was a real one. Bradshaw could not actually answer the question. There was no settled law that gave a court power over a king. The court's only true answer was force the army outside the doors. And so, for day after day, the same scene repeated. Bradshaw would demand a plea. Charles would demand to know the court's authority. Bradshaw would insist the king had no right to question the court. Charles would calmly insist that a prisoner questioning the court's authority was the most fundamental right of all. The king, famous all his life for a stammer, spoke in that hall with a steady, cutting clarity. As the king kept refusing to plead, the trial began to strain at the seams because a defendant who would not recognize the court created a genuine legal crisis under the legal procedure of the day. A defendant who stood mute and refused to plead could simply be treated as if he had confessed. His silence could be taken as a guilty plea. But the men running this trial wanted more than that. They wanted the king to engage, to argue, to be convicted on a record. A king hanged on a technicality of silence was not the public reckoning they had imagined, and the proceeding was not as united as it looked. On the very first day, when the clerk read that the charge was brought in the name of the people of England, a voice rang out from the public gallery. The voice belonged to Lady Fairfax, the wife of Sir Thomas Fairfax, the most senior general of the New Model Army itself. Even the family of the Army's own commander was divided over the trial. The soldiers in the hall were ordered to point their muskets toward the gallery. Lady Fairfax was removed. Order in the hall was kept by the army, and in particular by a hardline officer named Colonel Daniel Axtell, who commanded the guard. When the king passed through, some in the crowd cried out, "God save the king." Axtell wanted a different sound, and the soldiers did cry out. Witnesses recorded ranks of armed men shouting justice and execution inside the hall. Some of them, it was said, prompted and pressured by their officers. The line between a court of law and an armed camp was growing very thin when the court finally moved to hear evidence. It did so, partly in the king's absence. In a separate chamber, around 30 witnesses testified that they had seen Charles under arms in the field with his armies during the war. But this, too, revealed the strangeness of the trial. No one genuinely doubted that the king had fought the Civil War. The entire kingdom knew it. The real question was never the facts. It was whether fighting that war as king could be called a crime. On Saturday, January 27th, 1649, the court assembled to pass judgment. And on that final day, something unexpected happened. The king asked to be heard. For days, Charles had refused to recognize the court. Now, facing sentence, he made a new request. He asked to address not the court, but a joint meeting of the Lords and Commons in a different chamber. He hinted he had a proposal to make some historians believe Charles may have been prepared at the very end to offer to abdicate, to give up the throne in favor of his son, to save his own life. We will never know, because Lord President Bradshaw refused the request. The court decided the request was only a delay. It moved to judgment before passing sentence. Bradshaw delivered a long address defending the court, arguing that there was, in fact, a contract between a king and his people, and that a king who broke it could be held to account. Charles repeatedly tried to interrupt, tried to speak, and now the court would no longer let him. The clerk rose, and in the great hall of Westminster, before the king, before the army, before the crowded galleries, he read out the sentence of a court upon a reigning king. As the sentence ended, the commissioners who sat as judges were asked to stand to signify their assent. And the record notes that they rose only now. With the sentence pronounced, did Charles truly try to speak at length? And now it was too late. The execution was set for Tuesday, January 30th, 1649. A wooden scaffold was built outside the banqueting house in Whitehall against a building painted on its ceiling with images glorifying the very monarchy Now, being cut down, the morning was bitterly cold, and Charles made a request. That became famous. He asked to wear 2 shirts on the scaffold. Charles was allowed to make a final speech, but the crowd had been pushed back so far by the lines of soldiers that almost no one could hear him. So the king spoke mainly to the few men on the scaffold itself, and his last words were a final, unbroken statement of everything he had argued in that hall. Charles I was beheaded with a single stroke. An eyewitness, a young man in the crowd, later wrote that at the moment the blow fell, there rose from the thousands of people gathered in Whitehall a sound he never forgot, a low, collective groan, unlike anything he had ever heard. The execution of Charles I was an event without precedent in European history. A reigning king had been tried by a court of his own subjects, convicted, and publicly put to death. England abolished the monarchy. It abolished the House of Lords. For the next 11 years, England was a republic called the Commonwealth and was, for much of that time, governed by Oliver Cromwell as Lord Protector. The trial's organizers had killed a king, but they had not, in the end, built a lasting republic, because in 1660, just 2 years after Cromwell's death, the English monarchy was restored. The dead king's son returned from exile and was crowned King Charles II, and the new king's government hunted down the men who had killed his father, the judges and officials who had brought Charles I to trial, were now themselves put on trial as regicides, the killers of a king. John Cook, the prosecutor who had built the legal theory, Colonel Axtell, who commanded the guard, and others were convicted and executed. John Bradshaw, the Lord President, the man in the steel-lined hat, had already died. His body was dug up and put on display, and yet the trial could not be undone. The English monarchy came back, but it never came back the same. No English monarch after 1649 could ever again truly believe that a king was beyond all earthly accounting. Within 40 years, another king would be removed, this time without bloodshed, and Parliament, not the crown, would become the settled master of England. The trial of Charles I was, in almost every legal sense, irregular. The court was invented for the purpose. The Parliament behind it had been purged by soldiers. The defendant never accepted that the court could exist, and yet the idea at the center of it outlived every man in that hall. The idea spoken aloud for the first time that even a king holds power in trust, and that no one, crowned or not, stands above the law. If you want to come with us to other courtrooms, to the trial of Joan of Arc, to the dock at Nuremberg, to a Los Angeles courtroom where the whole world watched a verdict come in, subscribe to the highest court, because sometimes a court is built for a single purpose, and the verdict it hands down outlasts the men who feared to sign it